Donald Trump has just threatened to sue Trevor Noah, not for an investigative report, not for a news article, not for a factual expose, but for a joke, a 30-second line delivered on the Grammy Awards stage about Jeffrey Epstein's island. And that distinction matters far more than most people realize, because this has nothing to do with protecting Trump's reputation and everything to do with weaponizing defamation law as a tool to intimidate, chill, and ultimately silence speech. And from a prosecutor's perspective, Trump has stepped directly into a legal minefield that risks exposing far more than he appears to understand or intends to reveal. So pay close attention to what happens next. On Sunday night, February 1st, 2026, during the Grammy Awards, Trevor Noah hosted the ceremony for the fifth and final time. Billie Eilish won Song of the Year for Wildflower. And in the natural rhythm of a live awards show, Noah delivered a joke, saying that it was a Grammy every artist wants almost as much as Trump wants Greenland, which makes sense because Epstein's island is gone and he needs a new one to hang out with Bill Clinton. The audience laughed. Noah added, "I told you it's my last year. What are you going to do about it?" And within hours, the moment passed like thousands of other jokes that land, get a laugh, and disappear. Except this one didn't, because by 10:01 a.m. the next morning, Trump went to Truth Social and posted not a casual dismissal or a denial, but a roughly 300-word legal threat. And the wording of that post is critical. Trump wrote that Noah said incorrectly that Donald Trump and Bill Clinton spent time on Epstein Island, that this was wrong, that he could not speak for Bill Clinton, but that he had never been to Epstein Island, nor anywhere close, and that until that night's false and defamatory statement, he had never been accused of being there, not even by the so-called fake news media. And then the tone escalated into an explicit threat, calling Noah a loser, telling him to get his facts straight fast, warning that lawyers would be sent to sue him for plenty, invoking George Stephanopoulos and CBS as examples, and ending with, "Get ready, Noah, I'm gonna have some fun with you." Trump's reference was not accidental. He was pointing to two recent high-profile settlements that reinforced his belief that defamation threats work. ABC News paying $15 million after George Stephanopoulos stated Trump was liable for rape when the legal finding was sexual abuse, and CBS paying $16 million over a disputed edit of a 60 Minutes interview. Settlements that did not represent admissions of falsehood so much as calculated business decisions to avoid prolonged litigation. Buoyed by those outcomes, Trump appears to believe he is legally untouchable. But this is precisely where the danger for him begins, because what Trevor Noah said was not a news report asserting a verifiable fact. It was not presented as journalism. It was a joke delivered by a comedian on an entertainment broadcast before millions of viewers who understood the context as satire. And satire involving public figures occupies an entirely different legal category than factual reporting. Even more critically, there is something Trump's legal team should have noticed before he hit send, because just 3 days earlier, on January 30th, Trump's own Department of Justice released more than 3 million pages of documents related to Jeffrey Epstein, pursuant to the Epstein Files Transparency Act, with Deputy Attorney General Todd Blanche standing at a podium, telling the public that the release represented full compliance with the law, and those files are not vague or neutral with respect to Trump. His name appears more than 3,000 times. The documents include emails in which Epstein and his associates circulated news articles about Trump, photographs of Trump at Epstein properties, internal correspondence from the Southern District of New York, stating that Donald Trump traveled on Epstein's private jet more times than previously reported or understood, testimony from an Epstein victim who said Ghislaine Maxwell made it clear she was available for Trump and his friends, with the file noting nothing occurred but recording the implication of access, and testimony from Trump's own Mar-a-Lago staff describing frequent socialization between Trump and Epstein, albeit with Trump dining separately in the kitchen, rather than at the main table. Trump has repeatedly denied wrongdoing, has never been charged with any Epstein-related crime, and neither has Bill Clinton, and both deny knowledge of Epstein's criminal activities. But from a prosecutorial standpoint, the key question is not guilt, it is exposure. If you threaten to sue someone for defamation over a joke linking you to Epstein's island, do you really want to open the door to discovery regarding your relationship with Jeffrey Epstein? Because that is exactly what a lawsuit would trigger. Noah told a joke. Trump threatened lawyers. But before examining why such a lawsuit would almost certainly fail on the merits, it is essential to understand what Trump is actually trying to accomplish. because it is not victory in court. Trump's litigation strategy has never been about trials. It has been about deterrence. Over decades, he has filed dozens of defamation suits, settling some, losing most, but consistently achieving his true goal, which is to make critics calculate risk. When Trump sued ABC and CBS, those were large institutions with resources, but even they chose settlement over years of legal warfare, not because they lacked First Amendment defenses, but because litigation is expensive, distracting, and unpredictable. $31 million in combined settlements sends a message, and now Trump is applying the same playbook to a comedian, but with a fatal difference. Trevor Noah did not make a factual claim. Under Supreme Court precedent, particularly Hustler magazine versus Falwell in 1988, satire and parody about public figures enjoy the broadest constitutional protection. To prevail in a defamation action, Trump would need to prove that Noah made a false statement of fact about him, that it was published, that it caused reputational harm, and because Trump is the sitting president of the United States, he would also need to prove actual malice under New York Times versus Sullivan, meaning that Noah knew the statement was false, or acted with reckless disregard for its truth, a standard that cannot logically be applied to an obvious joke. In Hustler, the Supreme Court unanimously held that an outrageous parody implying Jerry Falwell had an incestuous encounter in an outhouse could not be defamatory, because no reasonable person would believe it asserted real facts, with Chief Justice Rehnquist emphasizing that robust political debate inevitably includes caustic, offensive, and exaggerated speech, and warning that without such protection, satirists and cartoonists would be crushed by damages awards. Apply that reasoning here. No reasonable viewer believed Trevor Noah was breaking investigative news about Trump's travel history. They understood he was making a satirical comparison drawing on Trump's documented social proximity to Epstein, and the laughter itself is evidence of that understanding. Yet the strategic problem for Trump goes deeper, because if he files this suit, discovery becomes unavoidable. Discovery would allow Noah's attorneys to subpoena every communication between Trump and Epstein, every email, text, phone log, flight record, and calendar entry, to depose Trump under oath about the nature and frequency of their relationship, to question Mar-a-Lago employees, to examine the newly released DOJ documents, line by line, and to force sworn answers about what Trump knew and when he knew it. A prosecutor would never voluntarily invite that level of scrutiny if the objective were to win. But Trump is not acting like a prosecutor. He is acting like a politician, attempting to control narrative momentum. The timing is revealing. The DOJ releases 3 million pages of Epstein files and is immediately accused by congressional Democrats of withholding millions more, with Representative Ro Khanna and Representative Robert Garcia publicly challenging the administration's claim of full compliance and suggesting a cover-up. Trump is under pressure, the Epstein issue is back in the spotlight, and then 3 days later, a nationally televised joke reignites the connection, giving Trump an opportunity to pivot from defense to offense by portraying himself as the victim of false accusations. But Trump's own Truth Social post exposes a critical flaw. He insists he has never been accused of being on Epstein Island, yet Noah never said he was. The joke was about Greenland as a replacement island, a layered satirical reference that only works if the audience understands the broader cultural context. Mischaracterizing a joke as a factual allegation will not survive judicial scrutiny, particularly when the DOJ files themselves document extensive contact between Trump and Epstein across multiple properties. Truth is an absolute defense to defamation, and even without reaching that point, satire alone defeats the claim. This is not just about one lawsuit. It is about a systemic attempt to chill speech by exploiting the cost of litigation. When media outlets and entertainers know that even accurate or humorous criticism can trigger years of legal exposure, they self-censor, soften language, and avoid uncomfortable topics, a phenomenon the Supreme Court explicitly warned against in Sullivan when it held that democratic accountability requires breathing space for sharp criticism of public officials. Trump's approach exploits the gap between constitutional theory and practical reality, using process as punishment, but it carries a risk he may not have calculated, because every threat draws more attention to the underlying facts. The ABC settlement refocused public attention on the E. Jean Carroll verdict. The CBS settlement sparked scrutiny of interview editing practices, and this threat has already driven millions to search Trump's name alongside Epstein's. Trevor Noah, unlike a news network, has little to lose, is at the end of his hosting tenure, and is protected by the strongest First Amendment shield available. If Trump files this suit, he will be choosing the worst possible defendant and inviting the most dangerous form of scrutiny into his most politically vulnerable association, a move that looks less like strategy and more like hubris. Whether Trump ultimately files or not, the threat itself reveals a troubling pattern: litigation as intimidation, law as leverage, and speech as the casualty. The outcome will matter not just for Noah or Trump, but for journalists, comedians, and citizens who rely on the First Amendment to hold power to account, because the rule of law only functions when criticism is not punished by legal fear, and sometimes the loudest attempt to suppress a joke ends up amplifying the truth behind it. Then here's the continuation, picking up seamlessly in the same voice, analytical frame, and momentum, and staying in one single uninterrupted paragraph with no line breaks. What happens next is where this story stops being about a comedian and starts becoming a stress test for the American legal system itself. Because once a sitting president threatens to sue a satirist over an award show joke, the question is no longer whether the claim has merit, but whether the institutions designed to protect speech will actually do their job under pressure. If Trump files, the first battlefield won't be a jury trial. It will be a motion to dismiss, where a judge will have to decide whether the complaint even survives long enough to reach discovery. And that decision will signal to every journalist, entertainer, and critic in the country whether satire still enjoys the breathing space the Supreme Court promised, or whether intimidation has become an acceptable substitute for legal merit. Trump's lawyers would almost certainly try to frame the joke as a factual implication rather than humor, arguing that by referencing Epstein's island in Trump's orbit, Noah conveyed a defamatory insinuation. But courts have repeatedly rejected that kind of semantic gymnastics. When context makes clear the speaker is joking, exaggerating, or provoking laughter, rather than asserting verifiable fact. Judges do not evaluate isolated phrases in a vacuum. They examine tone, setting, audience expectation, and delivery. And an awards show monologue hosted by a comedian known for political satire is about as far from investigative reporting as speech can get. Even if a judge were inclined to indulge Trump's framing, the actual malice requirement would remain an insurmountable barrier, because recklessness requires a conscious disregard of known falsehood, and Noah's joke was rooted in widely documented public information about Trump's social relationship with Epstein, information that Trump himself has acknowledged in the past. But suppose, for the sake of argument, that the case survives dismissal, because sometimes courts allow weak claims to proceed in the name of procedural caution. That is when the real danger for Trump materializes. Discovery is not a controlled press conference or a carefully worded Truth Social post. It is a compulsory process governed by rules Trump cannot tweet away, and once invoked, it strips litigants of narrative control. Trump would be forced to answer questions under oath with penalties for perjury, to produce documents authenticated by custodians of records, and to submit to examination by attorneys whose sole job would be to probe inconsistencies, timelines, and omissions. Every prior statement Trump has made about Epstein would be compared against documentary evidence, every denial weighed against emails, flight logs, photographs, and witness testimony, and even if no criminal wrongdoing were established, the spectacle alone would be politically damaging, because litigation creates records that live forever. That is why seasoned litigators avoid unnecessary discovery like fire, and why the threat itself is often the endgame. From a prosecutorial lens, this tactic resembles strategic lawsuits against public participation, or SLAPs, which are designed not to win on the merits, but to burden critics with legal costs and psychological stress, a practice many states have moved to curb through anti-SLAP statutes, some of which could apply here depending on jurisdiction. If Noah's legal team invokes anti-SLAP protections, Trump could be forced not only to lose early, but to pay Noah's legal fees, turning the intimidation attempt into a financial and symbolic defeat. That possibility alone may explain why Trump prefers public threats to filed complaints, because a filed case invites judicial oversight, while a threat lives in the media ecosystem where Trump is most comfortable. Yet even unfiled threats have consequences, because they normalize the idea that powerful figures can respond to criticism not with rebuttal or transparency, but with legal menace, a norm that corrodes democratic culture over time. This is why the founders elevated speech protections so high in the constitutional hierarchy, and why modern courts have been so reluctant to dilute them, especially where satire is concerned. Satire functions as a pressure valve in a democracy, allowing society to critique power without violence, and when leaders attempt to suppress it, they often reveal insecurity rather than strength. Trevor Noah's offhand line, intended to puncture ego with humor, has now become a mirror reflecting the fragility of that ego and the extent to which litigation is being repurposed as a political weapon. Whether Trump files or retreats, the episode will leave a residue, reminding critics that jokes are being monitored and reminding courts that their role as guardians of the First Amendment is not theoretical, but urgently practical. If the system works, this threat will dissolve under scrutiny, reinforcing the principle that public officials do not get to sue their way out of ridicule. If it doesn't, the chilling effect will spread quietly, joke by joke, segment by segment, until silence feels safer than laughter.